All right, 11 o'clock straight up. My name is Diana Kelly. I'm the president and CEO of CampCalNOW, RV Park and Campground Alliance. Today, I'm excited to bring you a great webinar on the new laws for 2021. As we all know, last year got very confusing with what we could and could not do with COVID and removals and evictions, and there's some new things in place this year, and I'm excited to have Dan Rudderow, our lead attorney partner, join us today for this excellent bit of information. Dan's law firm represents the owners and managers strictly of RV and MH communities throughout California. And his practice includes not just managing our legal hotline, which is probably a big enough job, but also preparing rental agreements, park rules for communities, assisting with day-to-day management, operational issues, and then also litigation. So should you ever run into a situation where you have to go to litigation, Dan's going to have your back. And he is always there every time we need him. So without further ado, I am going to let Dan take it away. Thank you so much, Dan, for preparing this for our members.
Thank you, Diana. My pleasure. Hi, everybody. Good morning. Happy Wednesday. Got a lot of information to share with you on the new laws. So let's go ahead and get started. What we're talking about primarily today is we're talking about the new COVID eviction moratorium law that was signed into law on January 29th. It was through Senate Bill 91. And it's officially called the COVID-19 Tenant Relief Act, but it's extending the time periods that were originally established under the old COVID law, which that was through Assembly Bill number 3088. So if you're talking to your lawyers might be saying, oh, this was under the old 3088, and now something's different under the new SB Senate Bill 91. The difference is that this time the new law didn't just extend the same eviction notices and time periods, but this time the new legislation out of Sacramento also added provisions regarding the state's new emergency rental assistance program, where landlords and tenants together are encouraged to apply to the program in order to get some financial assistance from the program to pay for any back owed rent. I think if you've listened to some of my webinars last year, I think the California legislature was trying to have a stopgap measure until this year when they had hoped that California would receive some of this federal money. And that's what's happened is that we'll talk about in a moment. The federal government has given the resources and the funding for California to set up this rental assistance program. So this new program is now built into the new COVID law. So our first question, of course, is where does the new COVID law apply? What does it apply to and what does it not apply to? Like anything in a presentation, you should totally not rely on what I'm telling you and fill out your own eviction notices and serve them. This is for informational purposes only. I'm really going to try to give you a detailed summary, but the new law is very complicated. I hate to say, I know Diana just got done saying the old law was complicated. The new law is probably more complicated. My copy of the new law is about 31 pages long. So to break this down for you though, so you have a good summary, most of the lawyers are saying here that this new law does apply to non-payment evictions brought under the mobile home residency law, under the MRL. And the law also says it applies to non-payment of rent and neglect or failure to perform a lease condition under the normal landlord-tenant rules. I know our members at CampCalNOW are wondering, how does that work with the RV code? And the new law most lawyers are interpreting the new law that it does not apply to other types of evictions under the MRL for mobile home parks, such as substantial annoyance or rule violation evictions. And I think we all feel like a very solid argument could be made that the new law does not apply to our evictions under the RV code. A little complicated because, as I will talk about later on in the presentation, there is an exception. It appears that the new law does apply to your evictions where you try to evict your tenant in your RV park who's been with you less than 9 months with a 30-day notice without cause. It seems like, well, what's the problem with that? I mean, you know, I've got a tenant, he's been in my park less than 9 months. I serve him with a 30-day notice without cause. What could be the problem? And as I'll talk a little bit later, the new law seems to put a restriction that you actually, ironically, can only evict someone if they're at fault. And so there's been a couple cases I know I've had in my office where the tenant's lawyer has argued to the judge that the 30-day notice without cause under the RV code is insufficient because it doesn't comply with this new COVID law. So I'll go slow here just so that we're all on the same page and address that a little bit later. So just some of the basics that I think maybe you're already aware of. When we say that the new law extended the old law, I think we all recall that the old law talked about a covered time period that was between March 1 of 2020 up to January 31st, 2021. And essentially what the law has done is it's extended that January 31st all the way to June 30th. One of the questions that I see in some other webinars that I've attended this week and last week is some park owners have asked, what does it mean to collect COVID rental debt, and does that include utilities? And the answer is yes. When you're trying to evict someone for not paying rent or not paying utilities or other financial obligations, I've given you sort of what the law says here in front of you. The law is saying that yes, what we're talking about is anytime when you're terminating someone for rental debt, which means rent and other financial obligations. So this does apply when someone defaults on utilities as well as rent. So just like last time, and this should all be familiar to you, just as under the old law, under the new law, if someone doesn't pay the rent and you want to evict someone for non-payment of rent, you must again serve them with the specially worded 15-day notice. And yes, it's complicated in the sense that the new 15-day notice post February 1 needs to have different language in it. And some of that language talks about the relief assistance that's now available. So if you serve your notice on or after February 1, the 15-day notice must tell them that they have to, if they want to claim COVID reason why they can't pay the rent, they need to sign and return the attached COVID declaration to you within 15 days. And if the tenant returns the COVID declaration to you within 15 days and on or before June 30th, the tenant pays you 25% of the monthly rent for as many months as they haven't paid the rent, then you cannot evict. You can't evict the person. What you can do is still, you can later on go to small claims court and seek to recover the other 75%. Like the last law, technically under the new law, there is no rent forgiveness of rent. There is no law that got passed that says that you must forgive the rent, but there's some other laws that came up around that I'll talk about in a moment. But just wanted to keep this simple. Like last time, in order for the tenant not to be evicted, they need to give you the declaration within 15 days and pay 25% of the total amount of rent they owe you before June 30th. After June 30th, then the landlord can go to small claims and try to seek recovery of the other 75%. The statute does again say that you can require a new declaration, COVID declaration from your resident every month. And like I said, they still owe the full amount of rent.
So Dan, I just have a quick question. I might be a little bit confused. So this doesn't apply to RV parks, but it does apply to RV parks?
The argument would be that this 15-day notice that we're talking about here does not apply to RV parks. Because the new law, when it spoke about the 15-day notice, didn't make any reference to the RV law.
So an RV park owner can still serve their
3360, their 3360 or their 60-day notice.
Right, okay.
Now,
but we can't serve the 30-day no cause.
Correct. Because there's another statute that just says any and all unlawful detainers, no matter what kind of unlawful detainer, whether it be mobile home park, RV, landlord tenant, apartment, condo. There's another statute that we'll talk about in a moment that says any unlawful detainer has to be brought with cause before July 1. I guess after July 1, then things will be different, but we're talking before July 1. Okay. So the lawyers are saying, well, when it says any unlawful detainer has to be brought with just cause or no fault or at fault just cause, we have a problem with our 30-day notices because those are served without cause.
Right. Mm-hmm. Right.
So, and thank you for asking that question, because that's what our listeners are asking right now is, well, does it apply or doesn't it apply? And the answer is, it may apply to some of your RV evictions, depending on who you're evicting, and then it may not apply to your other evictions. And just the way you summarized is the more detail. So this is just, this is more that if the COVID law does apply to your RV eviction, and the notices that you would have to give out, and the notices talk about the rental assistance program. Tenants may apply regardless of citizenship or immigration status. That's actually in the law. And in the notices, in the 15-day notice, there's language in there referring the tenant to their website and the phone number for more information on the rental assistance. I know this is a lot of information on this slide, but I just wanted to kind of give you guys the summary of the rental assistance program if you are applying with your tenant for rental assistance. Because the federal government did give all of this money to the state of California, and the state of California then created this rental assistance program, which will begin on March 15th. The California wants to encourage you, the landlord, to try to get this assistance. So I'll talk about how the judge may penalize you, but for right now, you technically have a choice, and the choice that they're giving you is they're trying to encourage landlords to apply to the program for monies to pay the back rent. And if the tenant qualifies, the landlord can choose to accept funding that will pay 80% of the unpaid rent from this period of time, April to March 31st. But the landlord is going to be required to forgive the remainder 20%. So they've got this program where they've got a lot of money, and they really want landlords and tenants to apply for that money. And if the tenant qualifies for that money, and there's still money left in the program, then what they want to do is they want to pay the landlord 80%, and in exchange, they want the landlord to basically forgive or release or never ever seek the other 20% from the tenant. The landlord does not have to participate in the program, but I will talk about later on in another slide where the judge can basically sort of punish you for not seeking this assistance. So I think that's probably clear to everyone that now we've got the funding, and the law really wants you, the landlord and the tenant, to try to apply for the monies and see if that can't first help pay back the landlord at least 80%. Also, there's this thing called the February informational notice, which, if you've noticed, you've probably gotten a lot of email blasts from different organizations trying to give you a new law seminar in February. And there is a method to everyone's madness here behind the scenes, and that is that we're trying to get you this important information now in mid-February, because one of the provisions of the new law says that if the COVID law applies to your tenant, and if your tenant that this COVID law applies to, if your tenant owes you rent as of February 1, then you must serve that tenant with the informational notice. It's a separate informational notice, separate from the 15 days notice. You must serve them with the informational notice by February 28th. This is similar, if people are familiar with this law, there was a similar one that you needed to serve on your defaulted tenants by September 30th. So different lawyers call this different things. Around my office, we call it the September notice that had to be served by September 30th. And around my office, we call it the February notice, but it's technically, I think, referred to as the February informational notice. You want to, if you have a tenant where the COVID law applies, you want to make sure that you serve that non-paying tenant with the February notice by February 28th, because that's a prerequisite to anything else you do from this moment forward. That is, if you serve them with a 15-day default pay rent or quit notice, let's say a month from now on March 17th, you might get to court and the judge will say, I see that you served them with an eviction notice on February 17th. On March 17th. The judge will say, I have your March 17th eviction notice here in front of me. And then the judge will turn around and say, but did you earlier than March, in February, did you give this non-paying person who had rent that they owed you as of February 1, did you give them the February notice by February 28th? And if you say, no, I forgot, I didn't do it, that could preclude you from prevailing in your unlawful detainer. In fact, there was a webinar the other day I attended where some of the lawyers said that they've been in court and the judge had a checklist from the bench, and the judge asked them, did you serve the September notice by September 30th? And you either did or didn't, and it was kind of cut and dry as to whether or not you're going to be able to prevail. So that's the reason why we're having this informational webinar to you today. It was by no accident. We're trying to let you know that you're going to want to get with your lawyers and make sure that you don't miss the February 28th deadline.
What if somebody, defaults on their rent after February 28th?
That's what I just said. That is probably, you can make the argument, that's a good point. is you can make an argument and say, Your Honor, they did not default until March 1.
Right.
And this law says only if you had a default as of February 1, which would be February rent. Now we can get really, in the weeds and say, what if the rent wasn't due until February 6th? But I think the big purpose here, and that's a good question, Diana, is if someone owes you rent for February or prior to February of this month, either this month or prior to this month, you should get the February notice out. And I think an argument can be made, like you're saying, is what if they paid the February rent, they're current on the rent today, then what if they default on the rent in March? Well, the statute says you were only required to serve the notice if they were in default as of February. So
Okay.
I think you've got a good argument.
Okay. And I just want to let everybody know, I do see that there's a lot of questions, and we will have time
Sure.
set aside for those towards the end. So don't think we're ignoring you.
And this, so this is the part where the judge may penalize you for not seeking the rental assistance. There's a new provision of the COVID law that says essentially, and I'll summarize these paragraphs here, that if you file a lawsuit with your attorney to recover unpaid rental debt, that when you sue someone to recover rental debt, the law now requires that you attach to your lawsuit documentation that you show the judge that you as the landlord have made a good faith effort to go get the assistance. You're now required to show the judge in a declaration that the efforts you made as a landlord to try to go get the assistance. Now it's like, well, Dan, what are you talking about? You just told me earlier that it's optional, that I can go get the assistance or choose not to get the assistance. That's true. But later when you try to file the lawsuit, the law is going to require that you tell the judge if you made any effort to go get the funding. And when you get to court, the judge is going to say, well, did you make an effort to get funding? And you're going to say, nope, I decided not to. In that case, the law says, well, then the court may reduce the damages awarded for any of the amount of the COVID rental debt if the court determines that the landlord refused to obtain rental assistance from the program. And also, I guess you'd have to show that the tenant met the eligibility requirements and that funding was available. So it's your choice whether or not you want to try to go get the rental assistance and get that rental assistance to pay 80% and you waive the other 20%. But you need to keep in mind that if you don't try, that a judge may, reduce your damages and almost punish you for not making the effort. And so I think that this is very different from the old law. As you can see under the new law, the government is really trying to get everyone to use this rental assistance money. And it's not a carrot and a stick. There aren't that many carrots here, but I guess you could apply and get 80%. That's a carrot. But they're using the stick here that if you don't apply, the judge may reduce what is awarded to you at the end of the day.
So this new law seems really landlord friendly.
Yeah, exactly. And they put some timelines. I don't want to get too much in the weeds and have this be a little dry or a little too boring for everyone. They also said, if you're going to go forward and try to get this money from the judge, even though you didn't try to go through the rental assistance, we're going to not allow you to even file this lawsuit until July 1. So there's some issues there. One of the issues that I see is that what if you have a client, and this often happens, what if one of our CampCalNOW members or one of my clients want to just seek possession? That is, they want to do an unlawful detainer complaint and go through the process and tell the judge, we only want possession. We're not going to claim any of this COVID damages rent. The law seems to say that you don't have to do a declaration. You don't have to get tied up on all these issues with the judge. You can just go in and get possession. One of the things that you and your lawyer should discuss, though, is that something you want to do, because you may end up waiving a couple months rent, and that may not be a big deal to you as the landlord. But do you as the landlord want to waive any of your holdover damages where you served an eviction notice and they don't move out, and you can claim as damages that huge period of time between when your eviction notice expired and the day of trial? That period of time between when the eviction notice expired and your UD day of your trial, you can claim the holdover damages that someone is essentially squatting and using the space, even though you served an eviction notice a long time ago. Some of our clients are like, yeah, let's just make it simple. Let's just seek possession in court, and let's not claim any of this rent. Let's not claim any of the holdover damages. I think that's one way of going, but you can discuss it with your lawyer, because holdover damages might end up being a lot of money, just because in this COVID day and age, the court system is still very backlogged. We're not really getting trial dates from the judges within 2 weeks for an unlawful detainer trial like we used to. It's taking more like months. And so we have to be careful that we really don't know how long it's going to take us to get a trial in the court system due to COVID. And you might be giving up a lot by waiving your right to holdover damages. So just some issues that we're trying to tee up for discussion purposes so that you can discuss that with your attorney. Like last time, as I mentioned before, going back to the beginning where we talked about the eviction rules, and they give you a signed COVID declaration, and now they have up to June 30th to pay 25% of the rent, and you cannot evict them, but you can go to small claims court and you can get the judge in small claims to award you that other 75% in rent that you weren't paid. That is still on the new law, but they pushed the time out as to when you can go into small claims. That is, under the old law, you couldn't commence a small claims case, couldn't file a small claims case until March 1. They pushed the goalpost, moved the goalpost down to August 1st. And I think that really kind of screwed landlords. I'm sorry to be partial for landlords here and not seem more objective, but it seems to me, my own commentary on this is that, you know, we had this COVID law last year that said, okay, they can pay 25% of the rent, and you, the landlord, can sue them in small claims starting on March 1. And we went through that all the way up to January 29th. And then on January 29th, they signed a law and said, oh, no, we moved it from March 1 to August 1. And I can understand the politics behind it, not to get into politics, which they probably did that because they now this year have this funding for the rental assistance program. So they're really trying to encourage everyone to go get the rental assistance, and to encourage them to get the rental assistance, they're not letting the landlords go back to small claims now, extending that from March 1 to August 1. So very, very fun stuff. Diana, this is what I was talking to you before. You did a great job clarifying it, which was if you have a tenant who's been in your RV park less than 9 months, you typically you can evict that tenant in 2 different ways. For a person who's been in your park less than 9 months, You can evict that person for non-payment of rent with a 3-day notice, or you can serve that person with a 30-day notice without cause. And given different cases and different facts, it's often the case working with my clients that my clients would rather just do a 30-day notice without cause and keep it very simple for the judge, rather than get into a 3-day notice for non-payment of rent or figuring out what they owed on the utilities and making sure a 3-day notice is accurate and doesn't have any mistakes. We oftentimes have clients that say, you know what, he's been here or she's been here less than 9 months, just serve a 30-day notice without cause. This, Diana, is where I said, well, the COVID law may apply and prevent you from doing that.
Mm-hmm.
And that's why I called it finally the kicker. That's finally the kicker for our RV people, and also for our other types of landlord-tenant relationships in which you there are like 60-day notices to evict someone out of a condo or an apartment that you can do without cause. And why this is the kicker is because SB 91, we know it was all about people who couldn't pay the rent. And we know we have all these 31 pages of law that talked about non-payment of rent and preventing homelessness. But the kicker is that SB 91 amended this code section, CCP 1179.03.5, that says before July 1, a court may not find a tenant guilty of an unlawful detainer unless it finds one of the following. I have not put all of the following options down here in bullet points. Some of them are usually not very applicable, but the main ones is that in order for the judge to rule in your favor, the judge needs to find that you terminated your RV resident or tenant because based on an at-fault just cause or based on a no-fault just cause. And what's going to happen is that the judge is going to take the bench and say, you know, Mr. Rudderow, I understand that under the RV code, your client was only required under the RV code to serve a 30-day notice on the tenant without cause. And the judge is going to say, I understand that. But the judge is going to say, but now I've got this code section that says a court may not find a tenant guilty of an unlawful detainer. And the judge is going to say that applies to any unlawful detainers, unless I, the judge, find that this was an at-fault just cause or a no-fault just cause. And the judge is going to say, Mr. Rudderow, I don't see how this is an at-fault just cause or a no-fault just cause. You've basically put in here without cause in your notice. So we actually, it's not just our office analyzing the law and issue spotting for you guys. We actually have 2 different tenant legal aid law firms in our office, 2 different files in our office, where they're bringing pretrial motions trying to dismiss our unlawful detainer based on this code section. And so we don't have a ruling from the judge. There's different arguments we can make back and forth, but it will be interesting now that we have 2 legal aid societies that are bringing motions based on this code section. It'll be interesting what the judge says and how we go from there. So. Also, I want everyone to be aware that in addition to what we've been talking about today, so far we've been talking only about state law. State law, state funding, even though it was funded with federal money, we're talking about the state law and applying for this through this new state funding program. Separate and apart from all of that, which has to do with California law, as all of you have probably heard ad nauseum on the news, you've also heard about the federal CDC eviction moratorium order. And you should make sure that you're discussing the federal CDC eviction moratorium with your attorney as well. It recently, I think, was continued to March 31st, so the moratorium is still in place. And what it does is it basically tries to prevent you from evicting someone who has COVID, but the federal law says you don't need to comply with the federal law if you're in a state like the state of California that has a more aggressive, restrictive eviction moratorium law on the books. And so with mobile home parks, most mobile home park lawyers feel like the California new law is more restrictive. And most mobile home park lawyers are saying that this federal CDC order would not apply to mobile homes. But the problem is the reverse with RV parks. The California new law doesn't say anything about the RV code. So since it doesn't say anything about the RV code, we're all kind of excited over here trying to say that most of the time, not always, as we've discussed in this program, but most of the time, the new California law is not going to apply to RV tenancies. But now we have an issue that maybe that means that the federal moratorium will apply to RVs. We've not yet had an RV eviction where Legal Aid Society has argued the federal moratorium. And this one is less restrictive in the sense that under the federal eviction moratorium, you, the landlord, are not required to hand them the declaration about COVID that they return to you. They can go get the declaration off of a website and bring it into the park office, and then you have an issue whether or not under the federal COVID you can evict them. I would suggest not punting, but I would just suggest that if you ever get a CDC COVID declaration, you definitely review that COVID CDC declaration that you got from your tenant with your park attorney. And one of the things the attorney obviously will do is it will look at the declaration and it will see if the declaration includes all of the things that it must include under the CDC order. And here are, 1, 2, 3, 4, 5 bullet points of things that the CDC order say the declaration should contain. So you'll want to look at that with your lawyer. Maybe there's an argument that they gave us some stupid declaration from a website that doesn't comply with the CDC requirements for declarations. So that's something you're going to want to go over. There's also briefly, in November of 2020, there's some new OSHA regulations that updated the coronavirus prevention and testing and reporting for employers. So that's something you're going to want to get with maybe your employment lawyer or your park lawyer. We can help you with questions about that. But the new OSHA regulations have things like requiring you to create a written COVID prevention plan, which you can get a template off their website. Certain precautions you need to take, providing free testing to employees that have exposure, screening employees, just the things you think that probably by now that OSHA is requiring employers to do. I did notice that they're saying that it doesn't apply to one employee who doesn't have contact with other employees or employees that work from home. I think a lot of us are working from home, and a lot of park managers are probably working by themselves in the park office, maybe with the door locked, having people ring the doorbell, transfer rent checks and signed rental agreements through the door slot at the front door of the park office. So, these you can get with your lawyer and try to see if the OSHA regulations apply if you're talking about one employee that's essentially, not having contact with other persons because you've locked up your park manager by himself or herself in the park. I think that's basically it. I think we did really good time on time. I mean, we're about 11:40. So Chris, do you want to
Yes.
come in? Or
I'll go
ahead.
ahead with the questions, Dan. And I think for me, the takeaway, because we get questions here in the office all the time, right? And so the takeaway for me right now is that it might behoove all RV park owners and operators to utilize the legal hotline anytime that they're going to serve an eviction, just to make sure we're all doing the right thing. It used to be fairly simple. You know, if it was a tenant under 9 months, 30 days, no cause. The next step was, you know, you're 3 and 60. But with things getting a little bit more complicated, whether or not the the new law applies to RV parks, I think one of the other things that happens is that there's this public opinion out there, right? So the news says, oh yeah, sure, you can get, free rent, just don't pay. You've got COVID, sign this form. And the tenants don't necessarily understand the nuances. So you may still find yourself in a situation in an RV park because a tenant's like, oh, no, you have to follow all these things. And the tenant doesn't realize that, what he's saying may only apply to mobile home parks. And so there can be a lot of confusion. So my guess is at this point in time, if you're considering evicting someone, it might be a good idea to reach out to us and we can hook you up with a legal hotline, right?
Right. That's absolutely right. And we would be happy to field your questions. It is very complicated. Now that we've been really studying the law for the last 2 weeks since it was passed on January 29th, we've got a handle on it. And, it's important to reach out to the legal hotline because I just don't want people to be tripped on, forgot to give the February notice by February 28th. I mean, some of us, myself, and other lawyers in this industry are really trying to make an effort to get the word out in February. Please do the informational notice by February 28th. We don't want you to get into a situation where it precluded you from getting the relief you want in court.
Right. So Michael early on had asked if SB 91 applies to private RV parks and campgrounds. We now know that it does not, but there are other things that do, including the CDC, the federal information. Jonathan asked, we have a few non-COVID cases of poor payment, death. How does this change the thinking about these given notices?
Oh, good question, Jonathan. If it's a mobile home park and it's a homeowner who dies, then we get into a discussion of the heirs who pay the rent in order to sell the mobile home to a third party. With RV parks, if you have a resident who's been in your park for 5 years and the resident dies, you're usually reaching out to a family member to say, hey, I'm so sorry for your loss, but you need to, take your dad or mom's RV and roll it out of the park. If they really won't roll it out of the park, then yeah, you're confronted with the issue of what to do when you have to place a lien on there. So It's a little complicated, but I totally can talk to you, Jonathan, offline if you have that particular situation. Basically, Jonathan, we are going to try to create ways of removing the person from the space for a reason other than COVID if we can. If we can wrap that, the lawyers can wrap an argument around a rule violation, a material breach of the lease, something like that. We will try to go that direction because, as you can tell, there's just a lot of hurdles with the COVID law. And we'd rather not spend our time in court trying to litigate every single one of these hurdles. We are developing ideas to bypass all the hurdles and just try to not evict, and by not evicting someone for non-payment of rent.
Nita asked early on, do we also serve the 360?
Yes, and when you say 360, like for a mobile home park, Nita, now the 360 has been changed into a 1560, or what we can now call around the office a 15-15-60. So you've got the 15-day notice to pay rent or quit, the 15-day notice to perform covenants for the utilities, and a 60-day notice to terminate their tenancy. That,
Goodness.
I know, that can be, the law says that your informational notice needs to be served by February 28th, and the law is very specific, saying that you can just serve your 15, 15, 60 concurrently along with your February informational notice. Again, sometimes I think you should get with your lawyer and rather pause and say, do I really want to do a 1560 for non-payment of rent? They did default on the rent. Shouldn't that be what I want to do, a 1560 for non-payment of rent? I think, you know, have a brief discussion with your lawyer. Do you want to evict them for rule violations or something else? If you're totally convinced with your lawyer that there are no other grounds for eviction, it's just non-payment, then you can serve them with the 1515 60-day notice, which you have to include a copy of the COVID declaration. And hopefully you get lucky, and the 15 days that the tenant has to come down to the park office and return the signed COVID declaration to you, hopefully they don't sign the COVID declaration and return it to you. If they don't, then that's probably a good thing, and it allows you to more easily go through the court system and file your unlawful detainer action.
Now, if they don't bring that 15-day notice down, Dan, but they give you 25% of the rent, does that have an impact on that?
No, they have, in order for the tenant not to be evicted, the tenant has to do two things. He or she has to give you the declaration within 15 days. If they don't, they can be evicted. In addition to giving you, let's say in February, they today gave you the declaration within 15 days in February, then by June 30th, they have to pay you all of that 25%. And so that means they have till June 30th to pay you the 25%. The earliest you could then file an eviction is going to be July 1, because they gave you the declaration. They did the first part correctly. Now you have to wait and see if they do the second part correctly in giving you the 25% rent by June 30th.
Laura has a great question. If you take the 80% funding and agree not to evict, how long is that good for? When could you evict the tenant down the road?
Oh, that's a great question. And I think I'm going back to, I have a hard copy of our slide. The 80%, landlords can choose to accept 80% of the unpaid rent owed from April 1, 2020 to March 31st, 2021. And then qualified tenants may be able to access funds to cover 25% of prospective rent for April, May, and June of 2021. So it looks like that the answer is going to be that, Laura, it looks like that's going to prevent you from evicting someone up through March 31st. The tenant might be able to get the 25% rent in April, May, or June, but that's not the landlord participating. That's just the tenant going and trying to get that rent. So keep in mind that the program hasn't even started yet, which is insane. The fact that they passed this limiting landlord rights as of June, well, they signed it on June 29th and the law went into effect February 1. And now we're at February 17th, and we're not even going to have the new program opened up for applications until March 15th. But Laura, I think what the answer is going to be is that if you apply with the landlord and the tenant apply and they get 80% of the rent and the landlord forgives the other 20%, that's going to cover up through March 31st. If they were to default on the rent on April 1, 2021, I would think it would be a whole new ballgame of evictions and going through the process.
We have quite a few questions about the percentages, including utilities. Does the 25% that the tenant is required to pay include utilities or rent only? That's from Nicole.
Usually so far, I'd have to go back and look at this precise question, Nicole, but the rental assistance program, and I think I'm answering the question by not answering the question, but I know that the rental assistance program about getting that 80% does cover utilities, but your question is
She actually asked both ways, so.
okay. I think
yeah.
I just heard some other attorneys. I think that the rental assistance program actually says utilities. It actually, in my PowerPoint, the program says utilities arrearages will also be eligible to be paid subject to funding availability. So I know that you can get rental assistance to pay the utilities. The other question is, is that a tenant can not be evicted if they give you the declaration and pay 25% by June 30th. I believe the law is saying pay 25% of the rental debt, and rental debt includes both rent and utilities.
Mhm.
So it would be, 25% of the grand total.
We have an anonymous up here that says, what about not evicting and just waiting until the COVID issues are gone?
Why didn't the person identify themselves? It's such a great question.
Right?
I think that that's where we were, right? 6 months ago when we had the new COVID law, the first one. Most of us, took a deep breath and said, gee, this first COVID law last year is pretty complicated. Seems kind of, partial against the landlords. And we did have an awful lot of park owners who took the road of just trying to work it out with the tenants.
Yeah.
And, try to sit down and kind of get half a lump, right? Try to tell the tenants, hey, tenant, I understand you supposedly, are affected by COVID. Many people are. I'm really sorry. You still owe the rent. That's California law that, rent's not forgiven. But I will, work with you. How much can you pay? Could you pay 60%, 50%, 70%? How about 75% is probably where you should start in your negotiations, but I'll leave it up to you, the park owner. But a lot of park owners were, making payment plans over time, whatever you want to come up with, a year or whatever, that they have 12 months to pay that, they'll pay 75% of the rent every single month, but that extra 25% is paid later starting on a certain date. So your question is should we just wait and do something later? Well, like I said, you probably should get the February notice out by February 28th and get that done. And then if you want to wait till later after it blows over to do something, then certainly that's your choice. But I'm concerned that if you need to do the February notice now, because what if you lay low and you decide in August or September, now you want to do something about it. And now I want to do an eviction notice based on non-payment of rent. Well, you might have, screwed yourself by not doing the February notice. So, so you want to be careful when you say, let's do nothing and wait till later and do something about it later. Well, if what you're going to do later is based on non-payment of rent, then today you should do the February notice. Yesterday on another webinar, people said, do I need to give the February notice to everyone in the park? And the answer is no. You need to just give the February notice to people who owe you rent, not everyone in the park.
What's the purpose of that February notice if you don't use it like for every month? I mean, why only February?
I don't know. They kind of created this law, and when they created the law last time, they came up with that. I think the last law was, when was the last law? The last law was signed into law in the evening of, I think, Monday, August 31st. And they included that same thing, that they wanted you to It's a good question, Diana, because what they did was they said no longer can it be a 3-day notice to pay rent or quit. It now needs to be a 15-day notice. Oh, and also in your 15-day notice, there's all of this information you have to give them in your 15-day notice, telling them about the COVID laws and whatever. So if I am required to put all this new language in my 15-day notice, then why did the legislature decide that in this very first 30 days, from September 1 to September 30th, we're going to require anyone who owes you rent as of September 1 to give them a second notice, and that's the only notice. You don't give them a notice for October, November, December, January. You don't give them any more required notices. It was just the September informational notice. And then when they went through the old law and dusted it off the old law and then just updated some of the dates and pushed the dates down and extended what we're talking about today, extended the COVID law till June 30th, they just changed the date and just said, well, okay, what did we do last time? Well, we enacted the law on September 1 and we required a separate informational notice to be served by September 30th. Oh, okay, well, let's do that again. New law, February 1, and we're going to require this separate informational notice to everyone who owes you rent and get that served by February 28th.
So Judith, I'm going to get to your question in 1 second, but Deborah had one that kind of really ties into what you were just saying. So she said, so for an RV park, would an informational notice be required as well as the 1560? But only if they owe you rent up to February 1st. Anything after that, you're basically putting all of the information in the 15-day notice, so there shouldn't be a need for it, correct?
Well, we can make arguments. You should get with your attorney. I know that's like a punting on the question, but if we're going to make an argument that the new COVID law that we're talking about today was very specific about how it changed the MRL, but it was silent and didn't say it applied to the RV code, then a lot of lawyers are going to make the argument that the COVID law does not apply to your 3360 that applies to residents who've been there longer than 9 months. So it's not a 15-15-60, it's a 3360 for residents. Again, don't rely on the fact that I said that in a webinar and Dan Rudderow said that. I mean, because
that's exactly what we're gonna say.
I know, because, and the reason is why the lawyers keep giving all these disclaimers is because I tell people that over the phone, but I do say send over the file. And then when the lawyer gets the file from the client, the lawyer opens up the file. Turns out that the park manager was mistaken, and we all make mistakes. I'm not faulting park managers, but turns out that what the park manager told us over the phone or in a question was not right, that wasn't the kind of tenancy they had. And the lawyers can see from the documents and the file that it was a totally different situation. So what we are trying to do today is we are trying to do this presentation for CampCalNOW members to say to our CampCalNOW members, get with your lawyer, and there's a very good argument that the new COVID laws do not apply to your RV eviction. However, Dan Rudderow did say during his webinar that there might be an argument by the tenant and the tenant's attorney that maybe the COVID law does apply at least to the 30-day notice that you're serving tenants without cause. So that's the back and forth. So I'm going to say that your lawyer should be able to make an argument that 90% of the time, maybe another way of saying it is that the COVID law doesn't apply to your RV eviction. But Dan Rudderow said there's really a strong argument that 10% of your evictions may be governed by the new COVID law. So you just have to get with your lawyer and say, look, this is how long this person has been in my park. This is their rental agreement. This is why I want to evict them. Do you think that, we should do this or that? One of the things that we did for a client just yesterday, is that we're exploring with the client, doing a 30-day notice to the tenant but instead of saying without cause, we're putting cause in our 30-day notice. So we're trying to work within the RB code and yet not, and draft our RB notices in a way in which we won't hit roadblocks with the new COVID law. So we're trying to look at the two sets of laws and creating almost another animal that has never existed before. We're trying to be creative that way as well. Again, you know, the thing with clients and lawyers is you may be a client that wants to be very aggressive, meaning you may want your lawyer to go to the mat and argue how the COVID law does not apply to the RB code. And there are certainly arguments that your lawyer can make, or you might want to be more less aggressive, and you might just get with your lawyer and say, look, I don't want to go through this headache. I don't want you to make all these arguments and go to the mat. I want you really to, you, my lawyer, to work with my park manager to see if there's a payment plan that we can do with our RV tenant to let them stay, because they don't disturb other people. They, you know, they abide by the park rules. They're actually pretty good, decent people. At the same time, it's not really going to be sustainable to let them stay there for no rent or half the amount of rent. But, you know, maybe like this other person who asked this question on our webinar, you know, maybe I should work out a payment plan and let them pay 50% of the rent. And then after COVID is over, and in theory, when a COVID is over, the economy does better and people regain their jobs back. Maybe people's circumstances will change with the vaccine by July or August, and the person can then pay the full amount of rent and stay in your park. Different parks let their residents, different RV parks let their residents stay different periods of time. Some RV parks really want people out in 6 months, but I have other clients who have RV parks that let their RV residents stay for 6 years. So it just depends on kind of what your business model is.
So I do have a couple more very pertinent questions. So if you're comfortable staying on, we just have a few more here. But I will tell you that, you know, as a CampCalNOW member, you do have free access to our legal hotline team. So you can ask unlimited single subject calls all year long. So what a way to justify your membership, but to utilize our legal hotline, especially right now, because a couple of calls will more than pay for that. So, and this is incredibly confusing. So I would take advantage of those services. So Judith had asked, what if you serve the notice to evict with cause, but then they decide not to pay rent? Will we be able to claim the money owed without that February notice or the 15-day notice? So a little bit of bait and switch here. You know, you serve them for one thing, but now they're not paying rent. So can you still collect, but you haven't done those other things up front?
I think that the answer, the takeaway is going to be that my prediction, it's like, well, what do you mean by prediction? I mean, legally, eventually, whether it be before July 1 or after July 1, you probably can do that and seek from the judge payment of everything you're owed. But what I think is more in the area of what will happen as a practical matter is that, and legally under the new law, is I think you will be able to evict someone for, say, a rule violation, and then later in court, you will be able to recover the holdover damages. But I think you and your attorney should be very careful and actually not seek recovery of the 2 months rent covered by the 60-day notice, the unpaid rent, because when you go into court and say to the judge, Your Honor, it's my right. I'm evicting them. I want a judgment for possession, and I want a judgment for unpaid rent, and I want a judgment for holdover damages, and I want a judgment for attorney fees. Those are usually the 4 things that every single landlord is seeking or asking the judge to award. It's that second one that's got me bothered as an attorney. I think we're going to be fine seeking a judgment for possession. I think we're going to be fine asking for some attorney fees. And I think we're going to be fine asking for some holdover damages, which is, again, is that period of time they squatted on your land, and you're entitled to damages while they squatted between the period of time of when your eviction notice expired and the day of trial. What I'm cringing about is I think we need to be very careful when we go into our unlawful detainer trial based on a rule violation. I'm thinking we should not seek recovery of the 1 or 2 months of unpaid rent. We should just forego that and not seek it and just waive it, because I'm concerned that when we tell the judge, oh, Your Honor, this is a rule violation eviction, it doesn't have anything to do with rent. Okay, Your Honor, now I'm at the end of the UD trial, and this is what I would like you, the judge, to award. Your Honor, go ahead, and I'm asking you to award unpaid rent. The judge says, wait a minute, counselor, wait a minute. You said that this was an eviction based on rule violations, and there's a bunch of COVID laws that apply if you're ever trying to seek recovery of unpaid rent. So, not to get too much into the weeds, but trying to answer this person's question, I think that's where we're going to go. I think what we're going to do is we're going to develop strategies where we can do these evictions through the court system, but we have to kind of be careful what we ask for.
Last couple questions, because I know we're over time now. John asked too, do COVID laws affect rent increases? And are property management companies generally filling out their own pay or quit notices or having attorneys do it? And Kim, yes, the webinar will be available later, which we will get out to everybody.
Well, answering the second question, typically everyone contacts Rudderow Law Group to have their eviction notices done. I'm just kidding. I don't know what typically every single park manager does. I know this sounds like a big sales pitch, but it's just the reality. I mean, you know, there are a lot of notices, 7-day notices that our park managers know how to do very well. There's, you know, a straight 30-day notice without cause. Our park managers are trained very well to know how to do that. They can use the CampCalNOW hotline if they just want some free legal advice about, you know, how to change their 7-day notice and what have you. But if we're going to talk about, okay, now we need to evict this person and what is the proper eviction notice, then reach out to an attorney on the eviction hotline and talk to me or another lawyer on the eviction hotline and go through it about what you're doing and what the pitfalls are, because it is complicated. It's complicated, like I said, because the government now changed the law to have some tricks or bells and whistles in the new law, trying to encourage people to first apply for this rental assistance. So, so that's the rub. Diana, what was the first part of the question?
Do the COVID laws affect rent increases?
No, this question's come up a couple times, obviously. It does not affect doing rent increases. And the thing you'll hear from all lawyers is, while the COVID law does not affect rent increases, California does have its own anti-gouging law that applies to rent increases. And I believe if you and your lawyer look at the rent anti-gouging laws, the gouging laws say that landlords can't raise their rents more than I think 10%. And so, you know,
10% during a state of emergency. So yeah, that's correct.
Yeah. So you know, if you're not raising the rent by 10% and get with your lawyer and you and your lawyer look at this and say, yeah, it's less than 10% and the COVID law doesn't apply, then you're probably going to be fine. But again, we say this to mostly our mobile home park clients, but also our RV park clients. Always be careful how much you do a park-wide rent increase. If you raise rents really high throughout the park, those people are going to hire a lawyer. They might have that lawyer sue you in a failure to maintain lawsuit. So that's a discussion for another day, but we're all on the same page. Number one, you probably should get your rents up to market. Number two, yes, you probably should figure out how you can raise rents. And number three, you should be careful with your attorneys discussing how you're not going to raise your rents too high too quickly, that you're going to do it gradually over time, because
Right.
you don't want to trigger any adverse reaction or lawsuit.
And then Deborah had asked about where to apply for that back pay assistance program. Dan, if you have a link for that, I can also look it up, and we'll put it up on our website, and we'll also put it out in our e-news.
Sure, yeah, and actually, I'll give that to you today as soon as I get off, Diana. It's actually, the link and the phone number is in the law itself. And so, because the law says you have to give them this 15-day notice, and in the 15-day notice, you have to refer them to this website email address. So that's right in the statute. So I'll get that for you, and you can publish that out to everyone. I don't have it here in front of me right now.
Perfect. And then it looked like Dan, oh, can we get a, oh, yes. Yeah, Dan asked if we can get a copy of the PowerPoint. Yeah, absolutely. As soon as I have it, I will get it out to all the panelists, and we'll put it in our e-news and stuff as well. So for all CampCalNOW members, you will have access to this program after or as soon as I get it. I think I've answered just about everybody's questions. Did anyone have any other questions? We can certainly continue to answer them. If you would like to send them to me, I can get additional questions over to Dan, and we can get those directly back to you. But if there are any other questions, please put it in either the chat or the Q&A now, and we can ask. Otherwise, I think that's about it.
Great, Diana. Well, thank you, Diana, for inviting me to speak, and everyone have a great day.
Yes, you as well. And Dan, thank you so much. I really appreciate it. I think this is great information, and hopefully this has cleared it up for everyone. But everybody, thank you guys for joining us. We appreciate it. Have a great day.
You too. Bye-bye.
Bye.